Generally, what are the defenses available for strict liability actions? Okay. As we previously discussed, contributory and comparative negligence applies to negligence torts. It is not a defense in a strict product liability or strict liability action. Now, the negligence of the plaintiff might affect the award or the judgment. It may offset some of the damages that the plaintiff suffered. But again, it's not a plain defense to a strict liability action. Generally, assumption of the risk, however, in most jurisdictions is a defense to a strict liability action. Assumption of the risk requires that the plaintiff had recognized the risk that exists and then knowingly undertaken that risk. Okay. Now, how do you recognize the risk, or how do you show that somebody appreciated the risk that they were undertaking? Generally, this can be done through demonstrating adequate notice that the parties acknowledge some way the risk that exists. This could even be pointed out in a contract that the parties signed or initialed beside the notification of risk provisions that, hey, this could potentially happen. And then they went ahead with the action anyway. Okay. So assumption of the risk. And then particularly in product liability actions, misusing the product, not using it for its intended purpose in the way intended, can also be a defense to strict liability in those types of actions. Okay. So it could demonstrate that the product as designed, as manufactured, was not unreasonably dangerous. It was simply dangerous when used in this manner, which was not the intended manner. So again, these are your primary defenses generally to a strict liability action.